20-0315 VESPER versus Reinforce. Each side will have 20 minutes to make your argument. Apparently, you may reserve as much time as you want for rebuttal, but you're responsible for keeping track of that time. We have a clock that you may see that's in the bottom right of your screen. So there's a time. We are recording the argument both in audio and video, so that we can keep everybody straight when you begin your argument. Please identify yourself and your client. The video of the argument will be available on YouTube in a couple of days. We've read the briefs and the record, and we've conferenced the case, so the judges and I are familiar with the issue. So when you begin your argument, just launch right into what you would like to talk with us about. Counsel, you may begin.
Thank you, Your Honor. My name is Evan Shuby, and I am counsel for Lynn Forest Longhorn Ranch. And I'd like to reserve 5 minutes for rebuttal. Now, there's really 3 issues that are on appeal. The first one is the division of proceeds. The second one is abusive process, and the third one is ARS 33420. And I'll start with the first issue and work my way down. And with regards to the division of proceeds from the sale of the property, ARS 12-1218C requires that the distribution of the sale proceeds be in accordance with the party's interest in the property. And in this case, the party's interest in the property was determined by the 2011 ruling in the underlying family litigation. In the family litigation, the claims to ownership were actually litigated. The parties in that case, after about 3 years of litigation, entered into a family litigation settlement agreement that resolved ownership issues with respect to the property. And then, as set forth in the 2000 ruling, the court resolved the issue of credits and offsets from the proceeds of a future sale of the property. And the parties agreed that there would be no right of appeal to that ruling.
Counsel, what were the requirements for the circumstances of a sale? I mean, I suppose someone could offer your client $10, and that would not be an offer that you would want to accept. But does the judgment or the agreement define what was a valid offer and what isn't a valid offer?
No, Your Honor, there was no reference in the family litigation settlement agreement or the 2011 ruling that set terms with respect to what constituted a valid offer. And so in the absence of terms, perhaps you'd fill in the blanks with a reasonableness requirement. But what was clear in the 2011 ruling was that they were to follow a process to select a real estate agent, and that real estate agent was then to list the property for sale. Presumably, that was based upon the fair market value of the property as determined by the parties or the real estate agent, but there were no specific terms on the timing of the sale or the actual sales price. And the reality of it is, in today's real estate market conditions, I think that market or that property gets sold faster. But back then, the market wasn't near as hot, and I think the record said that there were no offers on the property. It was Miss Linforce's relationship with the neighboring property owner, Mr. Mintzmeyer, that raised the issue of a potential sale in October of 2014. And there's a fair amount of discussion about that offer, and I'll go ahead and jump into it because I want to talk about it a little bit later. But Mr. Mintzmeyer submitted an offer to Linforce to purchase the property for $350,000 back in October of 2014, but that offer required Linforce to finance the transaction that was contemplated by the offer. Nowhere in the 2011 ruling is there any requirement that Linforce or Miss Linforce finance the transaction. And when in the record, there was some email correspondence back and forth with Mr. Mintzmeyer and Miss Linforce, and it was clear in those email communications that Ms. Linforce was rejecting the financing of the offer, not the actual sale of the property. And there were a couple of reasons for that, but certainly I think as we set out in our brief, financing the property was an impossibility. It would have required Linforce to make payment to the Sherry parties on money that it didn't have. So Linforce or Miss Linforce was well within her right to turn down an offer to finance the property and still not violate the 2011 ruling.
So if she had wanted to accept the offer, she could have, but she would have had to have paid funds to the Sherry parties?
Correct, Your Honor. If Linforce would have turned into the lender, okay, Linforce still would have been required to comply with the 2011 ruling at the sale of property, would have been required to make the distribution set forth in that sale or in the 2011 ruling. Okay, but then also would have ended up financing a transaction for Mr. Mintzmeyer that by the time the loan amortized, she would have been 109 years of age.
Surely.
So that's our position. I don't think when you look at the plain language of the 2011 ruling or sort of the underlying surrounding circumstances from the family litigation, that you can create an inference that the court would have required Linforce to finance that transaction. The entire purpose of the family litigation is best we could tell, and certainly from the language in the 2011 ruling, the entire purpose was to unwind the parties' transactions. So from our vantage point, the court erred when it said that Linforce violated the 2011 ruling by rejecting the offer that Mr. Mintzmeyer presented, because Linforce did not reject the offer to sell the property, she rejected the financing of the property. That was made clear in the emails and in her trial testimony. With respect to the foreclosure of the Chino Valley property that's referenced, again, the plain language of the settlement agreement and the plain language of the 2011 ruling does not allocate specific credits to specific properties. Okay, what it does is it allocates credits to the net proceeds from the future sale of property. And that allocation is a real property interest. Okay, and when you look at the timing of the foreclosure of the Chino Valley property, the notice of trustee sale was sent out, I think, shortly after the 2011 ruling, maybe a month or so. The Chino Valley property was foreclosed 4 or 5 months after the 2011 ruling. I don't have the specific date in front of me, but it wasn't too far off. And at no point did the parties ever go back and try to amend the 2011 ruling. I think when you look at the language of the ruling, when you look at the fact that neither party moved to amend the 2011 ruling, that foreclosure does not have any effect on the party's real property interest in the property that was at issue in this litigation. And obviously, it's our position, as we said on a brief, that the court's redetermination of the party's interest in the property was improper. With regards to, if you don't have any more questions on that issue, I'll jump to the abusive process claim that we brought. The abusive process claim that we brought was based upon VESPER's stated purpose for bringing the litigation. Okay. VESPER admits that the purpose of this litigation was to obtain sole ownership of the property. Okay. And we don't have to guess, because as you saw on the record, there's emails to both Sherry Linforce. I'm using her first name so we can keep all the names separate, but there's emails to Sherry. There are emails to Diane by Mr. Crane. Both of those separate emails, or all of those separate emails, recognize the other party's interest in the property. And Mr. Crane makes very clear that only once one offer is accepted, all the rest are pulled back. And his goal is to end up legally owning the whole property. And so after he acquires the Sherry party's interest and he goes forth and tries to purchase Linforce's interest in the property, he can't. Linforce won't enter into a transaction with him to sell its interest in the property. So what Mr. Crane does is he brings a claim, but he doesn't reopen the family litigation. He doesn't file a quiet title action asking for the parties to determine their interest in the property. Okay. He makes a claim that he's the sole owner of the property based upon the quitclaim deeds. I should say, when I say he, I apologize, VESPER makes a claim that they're the sole owner of the property. Okay. That entire case, the issuance of the summons, the complaint, all the judicial processes that we lay out, was all for the purpose of obtaining an interest in the property. Okay. The judicial process, I've yet to see a case, and I'm not aware of a case, that says the judicial process is there to allow a party to obtain an interest in property that it otherwise could not obtain in an arm's length transaction.
Counsel, isn't that what then is the purpose of a quiet title action? What's the purpose of a foreclosure action?
The purpose of a quiet title action and a foreclosure action is to determine interests that already exist, or to, in the sense of a foreclosure action, to enforce rights that already exist. And that's wholly separate from obtaining and acquiring an interest.
Is it your position that VESPER knew going into litigation that they had no legal right to it? They knew that Linforce was the title owner, and therefore the abusive process comes in the fact that they're filing litigation that they know they're not over property that they're not legally entitled to own. That it's a false claim.
Yes, that's our claim. That's our position. I think when you look at the record, when you look at the investigative report, when you look at the emails, when you look at Mr. Crane's deposition and trial testimony about what his support was for the sole owner claim, it's simply, yeah, he's there to acquire an interest, not to determine what rights he had. He very well knew that VESPER was not the sole owner of the property, and proceeded down a path of litigation, and that was to further that goal of obtaining an interest, that illegitimate goal of obtaining an interest in property.
Well, counsel, he may have had a bad claim or a claim had no legal merit, but if he believed that they owned the property or seeking to use the legal process to enforce their rights, even if they're wrong about their rights. How is that an abuse of the process? That's a use of the process.
Well, we're looking at what his primary motive is, and utilizing a judicial process, and like I said before, we don't have to guess about what his primary motive is. He put it in writing for us to look at. His primary motive was to acquire, was to end up legally owning, was to obtain sole ownership of the property. And
well, but Counsel, how is that different from, as Judge Ferrugia said, how is that any different from a quiet title or a foreclosure action? You're doing that to obtain full ownership of the property that you believe you own. And I imagine there are foreclosure actions that have or quiet title actions that have no merit, but that wouldn't be an abusive process, would it?
It would not, and correct, Your Honor, it would not be an abusive process, but in a foreclosure action, those rights already exist by way of contractual documents. Right? So you're not acquiring an interest in the property. You're not going out and using the court to obtain an interest. You're enforcing a right that already exists.
Well, but perhaps the foreclosure documents are defective, which means that you lose, so you really don't have an interest. So you would certainly lose your claim, but I don't see how that would be an abusive process.
In that instance, Your Honor, and under that example, it's while the underlying claim may not prevail because of some problem with the documents, that I understand. There at least is a colorable argument that you have a right to enforce. And I think that's where the distinction lies. I mean, I guess it would be the analogy that may work closer to the facts that are before us case, if you want to analogize to a foreclosure, would be as if I drew up foreclosure documents on, I'll use Mr. Gross as an example. If I drew up documents, deed of trust that allowed me to foreclose on his house, if he did not make payments to me and then sought to foreclose on it because I wanted to acquire his interest in his house, I think that's probably more analogous than say for example, the normal everyday institutional lenders that we all know, the Bank of America, the Wells Fargo of the world, foreclosing on a deed of trust. I would like to reserve some time for a rebuttal. I'm at about 3.5 minutes left, so
sure.
I can answer any further questions if there's none, and then I'll wait for rebuttal.
Thank you, Counsel. Mr. Gross. Counsel, you're muted.
I had $1 for every time I've heard that.
I know, right? It gets a little hard to get used to. Your Honors, may it please the court, my name is Stuart Gross. I represent VESPER Properties, LLC. The trial court didn't err in its decision to distribute proceeds based upon the relative equities between the parties at the time of trial. Partition operates by statute, but it's based on equity claims. The balancing of these equities is at the sole discretion of the trial court. And in balancing the equities, the court took into account the issues raised by Linsfors with regard to the 2011 under advisement ruling. But the court, in taking into account that ruling, recognized that Linsfors and the other parties to that ruling completely violated it. It was not followed. I think Your Honor brought a question before, is what was the determination on sort of what the market value should be for the property and where it was found, where that was contemplated in the order. And actually it was. Internal Record 145 on page 5 of 6 begins where the parties were supposed to contemplate what the market value is and how they were going to sell it. So initially what they were supposed to do is get together and say, hey, this is the market value of the property. Here's what we want to list it for. And if we don't agree on that agent, Then we have to get another agent and then elect a separate agent, so on, to get to the point where everyone is now in agreement. All of this was supposed to take place within a stated period of time.
Okay, Counsel, but here, none of that is at issue, right?
Well, I think the trial court found that it was, because the reason why is they're attempting to use the under advisement ruling as a sword in terms of balancing the equities when the equities completely changed. And they never would have, and had all those things occurred, we wouldn't be here today. I mean, that's the biggest irony about this, is that all of this was in the hands of Linsfors and the other parties to that agreement. They did not have to have this occur. But what ends up happening is that one of the properties that was contemplated in that order gets sold at a foreclosure sale. And by the way, which took 8 months from the time of the under advisement ruling to take place. So they had plenty of time to get together to try to sell it. And then secondly, when it came to the other property, the Longhorn Valley Ranch property, there's no evidence of listings that took place until at least after a year when the court order was in effect. And even then, it doesn't look like anyone really, took the opportunity to, first of all, comply with what the court wanted them to do. And secondly, to go ahead and go forward with the sale, because I can guarantee you, Your Honors, that if one wants to sell their property, they can sell it. It's not, there was nothing in the under advisement ruling that said it needs to be sold at a certain price. You can wait forever to sell it.
But Counsel, don't we read, isn't there implied within the terms of that order a reasonableness aspect? I mean, the court orders that the property be sold. Does that mean it'll be sold to the first prospective buyer regardless? I mean, in this particular case, there's a request that the seller carry the loan.
Yeah, but not necessarily, Your Honor. I mean, first of all, even in that request, one of the things that the party said was, okay, yeah, I would like you to carry it, but it looks like we could pay this within 2 years. I mean, that was just part of a negotiation. There was never a purchase contract drafted. There was nothing. I mean, this was an offer that was made to say, hey, what is your counter? There was none. And I don't think that, a party, my client, who was not a party to any of that, who never had any interest, who never had the ability to make any decisions about what was going to be put forth in that settlement agreement, should not be affected by an under advisement ruling where the parties completely.
Counsel, when your client acquired its interest, is your position that they were wholly without notice of that litigation? That they just didn't know?
No, in fact, Your Honor, they were on notice of the litigation, and that is actually how they acquired their interests. But that doesn't mean that, at the time of a partition sale that occurs 9 years later, we now have to be bound to something that makes absolutely no sense in this period of time. That made sense 9 years ago or 10 years ago, but it didn't make sense 2 years ago when they were finally able to sell it.
So judgments are supposed to be followed until they don't make sense anymore, and then it's up to you to decide?
Well, Your Honor, the restatement, section 28 says that and I'll say this also, in the case law also says this as well, in Lawrence versus Department of Child Safety, doctrines of preclusion should be flexible and must give way when their application would frustrate other social policies based on values equally or more important than the convenience afforded by finality in legal controversies. So in other words, this order should not frustrate the trial court's ability to fashion its own relief in partition. And I think that's what the trial court based their decision on, and how it decided the partition action. I mean, here we have someone that basically let their property go. They let it go. I mean, this property was going to be foreclosed on in a tax lien foreclosure sale. Did not pay the taxes on it. Made very, very little attempts to even try to sell the property. My client comes in, literally saves the property from foreclosure, regardless of whether or not Mr. Sheeby considers that speculation. There is certainly no evidence brought forth that Linsfors was going to come in and try to save the property. I don't even believe they appeared as a party in that tax lien foreclosure action. So what I'm saying is, when there's a change in circumstances, it's pretty clear that when it comes to collateral estoppel, that a court does not have to be bound. Your Honors, I'd like to go and discuss some of the arguments raised with regard to the abusive process claims. The elements of abusive process are a willful act in the use of judicial process for an ulterior purpose in the regular conduct of proceedings. So what was the ulterior purpose here? To quiet title. The purpose was to have the court decide property interests. That's not an improper purpose.
But is it an improper purpose when your client knows who the owner is, when they definitively know that they do not own the property, then the Linsfors do?
Well, no, actually, my clients didn't know the extent of their interests at the time, and they believed that their extent of the interest might be that they are the sole possessor of the property. In fact, they were considered the record owner of the property at the time they brought the quiet title action. The county assessor believed that they were the record owner. Now, are those?
But your client knew that they purchased a limited interest in the property when they made the purchase. That, I don't think anybody disputes that. Well,
I mean, it might have been limited in terms of what they were purchasing at the time. But they brought the quiet title action to hear from any other interested party, and especially Ms. Linsfors, who we were unsure was going to be a necessary interested party at the time, considering the fact that she let the property go in a tax lien foreclosure sale. And there was no.
Well, counsel, I'm confused, and correct me if I don't understand the record correctly, but your client bought the Sherry plaintiff's interest and tried to buy the Linsfors interest, and Linsfors didn't sell. So when you are by trying to buy Linsfors interest, aren't you on notice that you're not the only owner?
Well, regardless of whether or not we could have been considered the sole possessor, which the court eventually found that we weren't, even if that's considered an improper motive, because that's the term I believe that Mr. Shuby has used. The mere persistence in litigation, even based on an improper motive, does not sustain a tort of abusive process. And there really is not one single process here that can consider to be abused. Not one. The process they bring up, especially bringing up a question of, well, this was a cut and paste complaint. Well, there was nothing cut and paste about the names of the parties, the description of the property, all of the things that had to do with the property. What was cut and paste was for certain was reciting the elements of a quiet title action. Well, I have to tell you that I cut and paste elements of actions from other complaints all the time. So do many litigators. And if we were forced to do otherwise, then there would be a bunch of litigators that would be being sanctioned in the courts constantly.
So there's the purpose of the litigation has to be something beyond what you're seeking in the action for there to be an abusive process.
That's correct, Your Honor. I would like to turn now to the arguments that we haven't gotten to, or at least have not discussed at all, and this is the court had erred in concluding that VESPER violated ARS section 33420 in recording the subject list pendants. As your honors know, the list pendant serves to two purposes. It provides notice to anyone interested in a piece of real property, and it also prevents third parties from acquiring interest in property during the pendency of litigation. The mere filing of the list pendants does not establish the validity of a plaintiff's claims. So the stated purpose of 33-420 is protecting clouding the title to property. But in this case, what was very unusual, which I have not seen in any case, is that Linsforce had never asked for the Liz pendants to be removed. And while
Counsel, is that a requirement of 33-420, particularly 33-420A, or is that just relegated to 33-420C?
Well, Your Honor, I think, 33-420A and 33-420B seem to imply the fact that you're bringing this action because that there's a violation of filing a groundless recording of a document. Certainly, if the intention of the statute, now you're right, and it doesn't state that. I read the statute the other day. It does not state that you have to affirmatively say that we want the Liz pendants removed. But what else could be the purpose of the statute? To get sanctions?
Doesn't 33-420C in fact say that before you can bring an action against an individual that you have to request that they remove it? And isn't there a penalty applied to that willful failure to remove it?
Yes, that's a $1,000 penalty, but 33-420A does not have that requirement.
And you would agree with me, though, that is then a different penalty than the $5,000 that's in A?
Yes, it is. But I'm not sure. Well, anyway, the point I'm trying to make is that, Your Honors, is that when you determine, whether or not the recording is groundless, you look at, okay, whether the action is one affecting title to real property. No one's arguing that here. It is. This is a quiet title action affects real property. But you go beyond that. I am not suggesting that you don't. What you need to look at is that the court needs to find some basis for concluding that the action affects title to real property. Well, here it does. I mean, no one is suggesting it doesn't. And I think what the hangup is, and has always been, is that the question has been whether or not if the sole possession part of the action, what is being requested, if that is groundless, does that then make the Liz pendants groundless? And it cannot. Because otherwise, it would require you to believe that you will win on the merits every time you record a Liz pendants for fear of then having a Liz pendants recorded that is considered groundless.
Counsel, run with me here.
Okay.
If you have a person who there's a group of people who believe that they can improve their title by giving themselves a deed that gives them it's called the sovereign citizen movement. Okay, and they're famous for recording Liz pendants and liens against people that have no basis in law. So if one of these people wants your property, right, and files a Liz pendants against your property because they're sovereign, they declared war on you, you didn't respond, and therefore now they have sovereign title to your property. So they record a Liz pendants and bring a quiet title action against you. Now, obviously, this is absurd. Okay, are you arguing that person did not violate 33-420?
No, I think there's quite a big distinction here. I mean, I think that in that situation where they're trying to make up property interests out of whole cloth, that's definitely different than when you're asserting quiet title action where everyone recognizes that both parties have the interests. The question is whether or not we have the sole interest in the property, which the court found that we did not. And even beyond that, the court found that there wasn't a basis for that argument.
Counsel, so if your client obtained Sherry's interest and knew that it did not at that point obtain 100% interest over the property or properties, property. At what point did VESPER become confused as to its status? At what point did it say Linfers have now relinquished their interest in the property, or we're just in this ambiguous place, we just don't know? When did that happen?
I think that happened during discovery. I think that happened when the arguments were set forth in the summary judgment motions. I think that happened.
After you filed the lawsuit? So you filed the lawsuit. I mean, shouldn't that have happened before you filed?
Well, yeah, I mean, there was an investigation. There was an investigation done. I mean, there were, it's not as if we didn't do anything. I mean, there's, it's in the record, and that determination to sole possession. But Your Honor, I think that we're missing the forest for the trees here. The decision on the merits, it has nothing to do with a recording of a lis pendens to tell the world that there's an action to quiet title. And beyond that, Your Honor, when they brought this action, okay, when we brought this action, they also asserted an abusive, they also asserted a partition counterclaim. So at that point, there could have been a lis pendens filed anyway. Everyone would have known that the property had a lis pendens attached. It's not incumbent on a purchaser of the property to figure out, are they going to win their sole possession action or are they going to lose it? That's not what a purpose of a lis pendens is. Your Honors, I'd like to just jump real quickly. There is one other issue in this where we're talking about the attorney's fees claim, and I just want to quickly get to that and reserve maybe a minute and a half for rebuttal. As far as the attorney's fees goes, we had argued that there should not be any fees that would have been, if the court obviously, does not dismiss the 33-420 action, then the fees come out of that action. That action did not start until almost towards the end of the claim. At that time, there were fees incurred, but the amount of fees incurred after the action was only $68,265, not the $103,000 requested. And there were other fees as well that we had stated in our brief that were either unreasonable or fees that should reduce, especially based on fees incurred in the purchasing of in the selling of the property. What does that have to do with that? And I think the court can make those distinctions, and I think the court can base it on what was the action, where did the fees derive from? I think this is the kind of case you could separate that from. I don't think most cases you can. Your Honor, I'm going to have to stop now. I've reserved about a minute and 15 seconds.
Surely, counsel. Counsel?
Yes, thank you, Your Honor. One quick follow-up on the abusive process issue, and we made the point in our brief, and I just want to make sure that it's clear here. Our issue on the trial court's October 2019 ruling is that the court stated that VESPER's litigation goal was to obtain ownership of the property or something to that equivalent. I don't have the language in the exact language in front of me at the moment. But then it shifted and said it's VESPER's business purpose that's legitimate. And as we've discussed earlier, it's not a party's business purpose that gives rise to an abusive process claim or defeats an abusive process claim. It's their litigation purpose. So I just want to make that point clear. With respect to the lis pendens issue, I'll touch base on just two quick things. One, there was discussion about whether or not Linfors subsequently sought to quash the lis pendens or have it removed. A liability under the statute is established when the document is recorded. So what Linfors did or did not do afterwards is irrelevant. Number two, with respect to the nature of the underlying claim, a couple of things. One, VESPER acquired its interest by way of a quitclaim deed. So whatever interest the Sherry, what we refer to as the Sherry parties had, that's the interest that Linfors had. So there really wasn't going to be much of a change or effect to title, and at least that's my sort of analysis on a quitclaim deed. But I think when we get to the issue of groundlessness, looking through the record, it's fairly clear that there was no basis for the sole owner claim, and that claim was never going to make it. Just like when we were the cases that we cited to, I think it's Coventry, Evergreen, Chevron talks about option agreements and other things that oral agreements are the statute of frauds. those claims are never going to make it, and therefore the liability under ARS 33420 attaches. And so, look, VESPER offered, during the course of litigation, VESPER offered 9 separate explanations for its sole owner claim. None of them had merit, and hence the reason why the trial court correctly ruled that VESPER was liable under ARS 33420. If you have any questions, I'm happy to answer them. It looks like you got about 40 seconds left.
Thank you, Counsel. I don't think we do. So because it's a cross appeal, you've got a very short time for rebuttal. Mr. Gross?
Yes. Your Honors, I'm sorry, what was the question that you asked me?
No, I'm just saying that you have a short time for your rebuttal.
Okay, thank you, Your Honor. Yeah, I would just like to again expound on what Mr. Shuby has just said, and it seems like, you know, in terms of the 33420 action, is what the trial court wrong and got wrong is exactly what Mr. Shuby is saying. We're not, the 3420, it's pretty clear in the cases, and especially the ones that were cited, that these cases, the reason why in certain of these cases where the lis pendens was considered groundless is because the parties in those cases, so the plaintiffs in those cases, tried to use a separate action, like a breach of contract, like a mechanics lien, all these things to say, hey, you know, maybe this has to do with property. Okay, so, you know, we're gonna hold up your sale of your property until we resolve the debt that you owe us. And that's exactly the reason why 33420 was enacted. It was not enacted so that when there are decisions that are made over interest in property that someone loses, and we admit that that is, we did lose the sole possession action. It doesn't mean that that action did not affect real property.
Thank you, Counsel. We appreciate your argument today. We'll take this matter under advisement and we'll issue a decision in due course. And we stand adjourned. And if the two judges can remain, I'd